for your time today and for your testimony. Mr. Epstein, on August 8, 2022, the FBI raided Mar-a-Lago, and the American people witnessed an unprecedented attack on the home of a former president by a politicized FBI. Almost a year after the raid on Mar-a-Lago, on June 7, 2023, Stephen D'Antuono, the former assistant director in charge of the Washington field office, sat down with the House Judiciary Committee for a transcribed interview as a part of this committee's oversight of the FBI. In the interview, Mr. D'Antuono described what he viewed as several abnormalities about the way in which that raid was conducted. Mr. Epstein, in a notice of claim filed in the DOJ in 2024, you argued that the FBI's conduct in the raid, where established protocol was violated, constitutes a severe and unacceptable intrusion that is highly offensive to a reasonable person, end quote. Would you explain to us today how the FBI's raid of Mar-a-Lago was inconsistent with standard protocols?
Well, Congressman, precisely as Mr. Antuono testified before this committee, that we have protocols. We let the attorneys know before the raid is going to be conducted. We typically use kind of the local office to be in charge of it, not the Washington field office to be in charge of that. And the protocols here were wholly inconsistent. And I think that's part of the concerns about when political goals inform what otherwise should be doing justice.
And why do you suppose they opted out of such protocols?
You know, I think here the tone was set from the top. I think and I'll just note that on this question of records and what was probable cause to do these investigations, so much of that was based off the views of the National Archives that these were records that were in the proper ownership of the United States. In large part because of America First Legal's work, we recently showed that the former archivist of the United States, David Ferrero, actually said that we should treat President Trump's records as if they were federal records. In violations of the Federal Records Act allows us to make referrals to the Department of Justice. That was an arbitrary, capricious, illegal determination that led to the ability for the Department of Justice to have probable cause to conduct this raid. And I think that's something that is a direct piece of evidence of politicization of the law.
Thank you, Mr. Epstein. Mr. Terwilliger, your client, Mark Meadows, is being sued by Fulton County, originally by the very partisan district attorney, Fonnie Willis. Meadows sought to have his court case moved to a federal court, arguing that was more appropriate because he was acting in the official capacity as Trump's White House chief of staff. After his bid was rejected by the Supreme Court, you argued that the risk puts former federal officials such as Meadows, quote, at risk of being left to the wiles of every politically hostile district attorney or state AG in the country. I happen to agree with you that something needs to be done to protect future former officials from being subjected to the type of lawfare that Mr. Meadows is facing. So my question to you, Mr. Terwilliger, does Congress have a responsibility to protect federal officials from lawfare?
Yes, sir, it does, and it has tried repeatedly to do that, and the courts have repeatedly pushed back for whatever reason, including in the Mesa versus California decision. What Mr. Raskin's comments miss is the fact that all federal courts, all inferior federal courts, other than the Supreme Court, are created by this body, by the United States Congress. You establish their jurisdiction. And what I'm suggesting to you very simply to do what you want to get done is that you incorporate standard federal question jurisdiction into the removal statute. So in a case like in Mesa, where the question was whether or not, if I recall correctly, postal employees could speed or not in doing their job, that those questions get decided by federal judges in federal courts. Otherwise, we have a an incredible body of confusion of state courts deciding federal questions. But it is important, because of the Mesa decision, to make clear that federal questions belong in federal court. And indeed, over decades, many federal courts have said the very reason for the removal statute is to have federal questions decided in federal court.
Well, thank you, sir. And I look forward to our markup tomorrow, in which this committee will be taking a look at important legislation seeking to address these issues and prevent future lawfare. Thank you, Mr. Chairman.
I think